Hi, my name's Chris White. Welcome to Law Talk, where you have legal questions, we have legal answers. I do work injuries, workers' comp, personal injuries, immigration, and if you have a problem in the law, a legal question, you can always call me. I'll help you or get you to somebody that can help you. Today we have Daniel Martin, who does criminal defense here in Fresno, California. Dan, introduce yourself.
Thank you, Chris. My name is Dan Martin. As you mentioned, I'm a criminal defense lawyer here primarily in Central California, but I've practiced all around the country. And
Okay.
I specialize in criminal defense and expulsion or educational law.
All right. So what's the typical problem that people call you about?
Well, I usually get contacted because somebody they care about or they themselves have been charged with a crime.
Okay. So this is always something I wonder about. Is it better to get a bail bondsman first or the lawyer first?
That's a good question, Chris. And sometimes then people will. The problem comes up where somebody they care about's in custody. They've been arrested, and they want to initially run out and go contact a bail bondsman. The problem is that they can spend all their money on the bail bondsman, which is important to get out of jail, but more importantly, and the one that's probably going to have the greatest effect on the outcome of their case, is having a lawyer. And so I advise people to consult with an attorney first, always first. And most criminal defense attorneys, and certainly I do this, I will meet with a client for free. The consultation's free. So consult with the attorney first, and then proceed after you've had the advice of the attorney, whether or not you need to go hire a bail bondsman, or you can wait until the attorney does a motion that can reduce bail for you. Okay. That'll all be decided after you've talked to the lawyer.
So it sounds like kind of an expensive proposition. You find yourself in jail, and you're stuck there until you get bailed out, and you got to pay a bail bondsman, and you got to pay an attorney. How much money are you talking about, like out of pocket, to get you?
Yeah, that's another good question. Well, okay. It is true in the United States that you are presumed innocent until proven guilty. That's true. The problem is it's still often very expensive to be charged with a crime, even if you're innocent. And so depending on the type of case, if it's a misdemeanor, and this typically is like a drunk driving allegation, in those cases, you can expect to get an attorney as long as nobody's been injured and you don't have an extensive criminal defense, extensive history of criminal problems, then you can expect to get an attorney from the neighborhood between $3,500 to $7,000 for a misdemeanor case. For felonies in state court, you can expect to pay between $7,000, and it just goes up from there.
You said you had a free consultation, but like you don't have to pay that all at once, right?
No, it depends on the attorney, but for the most part, at least I will work with people on payments, a significant down payment, like about half, and then they make payments for the rest of that. But every defense attorney is different, and so usually that's why it pays to meet with them and talk to them about your case.
Okay, let's get down to the nuts and bolts. Is it true my case is going to be dismissed if the cops forget to read the Miranda Rights?
Yeah.
Forget to read me my rights?
And that's a common misconception. Oh. And I think it comes from the news, from TV. We've all watched it. And most of us can recite the Miranda Rights because we've seen it on TV. And so I get a question a lot. People will say, they never read me Miranda Rights, so does that mean this case gets dismissed? And sadly, that's not what happens, actually. There's a lot of factors.
What happens?
Well, usually it has no effect on somebody's case. Yeah. Usually what happens...
You don't even have to read the rights.
No, there's no law that says you have to be read your Miranda Rights. This is a misconception. The case comes from Miranda v. Ohio. In that case, there was a person who wasn't read his Miranda Rights, and the Supreme Court said that if the government wants to introduce your statements at trial and you're in custody, then you have to have waived your right to have an attorney present. So that's what they talk about, the Miranda Rights. But if they haven't done that and they don't need your statements, and for example, if they have witnesses...
So they can still nail you on something other than what you said?
Exactly.
Okay. So I always hear I have the right to remain silent. Should I be quiet or should I talk to them? Because they really want me to talk to them.
They do want you to talk to them. And the reason why they want you to talk to them is because you talking most of the time will make their job of prosecuting you and ultimately convicting you much easier if you talk. As a defense attorney, I always advise people not to talk, because it's generally in their best interest not to talk.
Don't I just go directly to jail, don't pass go when I stop talking?
That's a fear a lot of people have. The reality is more often than not, people talk themselves into jail, not out of jail. If the officers have sufficient evidence to arrest you, they're going to arrest you, whether you talk or don't talk. And so if there's witnesses, if there's evidence that they can use, it's sufficient to convince a reasonable person that you're guilty, they're going to arrest you, whether you talk or not. But oftentimes, talking is the problem, because something you say can be misconstrued, or maybe it's not consistent with a different witness, and you may be innocent, but it's inconsistent with somebody else's version, and you'll find yourself in jail because you did talk. And more often than not, that's the case.
So how long is it going to be, like, from the time a person gets arrested to the time that they're actually dismissed or convicted? Or what happens? You plead. Most of the people plead?
Yeah, over 90% of criminal cases are resolved by a plea bargain. But there are statutory times. From the time when you're arrested, if you're kept in custody, there's 10 days, 10 actual calendar days, 10 court days until you have a right to have a preliminary hearing. That's a hearing where the prosecution has to bring evidence, sufficient evidence to convince a magistrate or a judge sitting as a magistrate that a crime's occurred and that you were involved. Then after that, there's 60 days until you have to go to trial. So when people talk about I have speedy trial rights, those have been recorded as being about 60 days before you can get in front of a jury.
Okay. All right. So, if I'm completely innocent, can I just do it on my own? Because they don't have anything on me anyway, right?
Yeah, and that's a common issue. People will say, but I didn't do it. I don't need a lawyer because I didn't do it, and this will all work it out. I would say that if you're innocent, you need a lawyer more than ever, because it's really important that you have somebody advocating for you. Sadly, there's not. Although there are more and more cameras everywhere we look, there's not a camera everywhere. And so the fact that you are innocent doesn't by itself mean that you don't need a lawyer. And it doesn't mean by itself that it's going to work itself out and that eventually people are going to realize that you're innocent. The reality is, if you're dealing with law enforcement, it's because there's some reason for them to believe that you're guilty or that you've done this. And so you being innocent by itself without having corroborating evidence or having witnesses to support your version of events doesn't mean that you're automatically not going to get in trouble.
What if I just use the public defender? I don't got that kind of money. I don't have $1,000, $2,000.
And that's an option, actually. You have a right to have an attorney, even if you can't afford one. And public defenders are very experienced attorneys. And I, in fact, worked for a public defender's office years ago. But the problem is, particularly in Fresno County, this is a significant issue. And it was in the news over the last 6 months about public defenders here that had caseloads that were excessive. And that's certainly true.
You mean I can't just pick up the phone and call?
You can't.
Will I talk to them?
You will probably talk to a public defender in the minutes while you're in court for a few minutes right before they call your case, but it's difficult to get their valuable time if you're not actually in court. More often than not, you'll call, leave messages, try to get a hold of them. But they have, on average, about 500 cases per public defender. So you're one of 500 people that they're fighting for, and it's hard to get
Has it always been that many?
No, the American Bar Association has disseminated that 200 felonies for each public defender is the recommended maximum. Anything more than that is considered excessive. And here in Fresno, it's not uncommon to find public defenders that have 500 cases or more.
Do they sometimes, like, say, this public defender's got way too many cases, so we're going to send some over to the private bar, to the private attorneys? Does that happen sometimes or no?
In Fresno County in 2012, beginning in 2011, and the practice pretty much wrapped up in 2012, the public defender, a gentleman named Ken Taniguchi, who's no longer the public defender, he at one point, because he was concerned about his duty as a public defender to adequately represent people, they refused to accept appointments. And so there was a time when Fresno County was actually paying private attorneys to represent people because it had gotten excessive. That stopped. There was a lot of pressure on him and the department, the public defender's office. There was a lot of pressure on them to not do that anymore because it was expensive. The county was paying hundreds of thousands of dollars for private attorneys.
Okay. So how do most people find your phone number, get into your door?
Well, People can find me in various ways. I'm on YouTube. I have a channel on YouTube. Primarily, they call the office at 559-255-3425, or they can follow me on Twitter at Valley Justice, VALLEYJUSTICE. I love interacting with people on Twitter, and then they can find me on Facebook, and that's facebook.com/Fresno Criminal Lawyer.
Now, I saw some of your YouTube videos. I was impressed. I was pretty cool. You were on the news a couple of times. I don't know if it was about criminal, but we're running out of time. Tell me the most important thing for people to know if they get arrested.
Most important thing is do not talk to law enforcement unless they have their attorney present. And then as soon as somebody gets arrested, or if you've been arrested or somebody you care about's been arrested, contact a criminal defense lawyer to make an appointment.
Contact you.
Me. Yes, I'm available.
Okay. Well, your phone number one more time.
It's 559-255-3425.
All right. Thank you very much.
Thank you.
This is Law Talk. If you have legal questions, we have legal answers. You're welcome to call in legal questions, or you can send an email. We'll get that information for you on the screen one of these days, or soon.